Good afternoon, everyone. My name is Alina. I am volunteer at the SHRM Programming Committee. We want to thank you for joining today's webinar entitled Post-Election Update. During today's presentation, if you have any questions, please feel free to send them via the question box of the GoToWebinar panel, and we will read them aloud to the speaker at the end of the webinar. We also want to remind you that you are eligible to receive one HRCI General Credit and one SHRM Professional Development Credit for attending today's webinar. You will receive a follow-up email after the webinar with a survey link that must be completed for you to receive the certificate for your credits. Once the survey has been completed, the credit forms will be emailed to you within 1 week. All slides will be sent to all attendees after the webinar. Today's webinar will feature Danielle Goebel, attorney of law at Dilworth-Paxson, and Catherine Hartman, partner in the Labor and Employment Practice Group at Dilworth-Paxson. Thank you both for joining us today.
Good morning. This is Catherine Hartman. The topic of today's webinar is the impact of the 2018 midterm elections on labor and employment issues. In fact, the midterms have already had an impact on employees and employers. For example, and perhaps most notably, employers and human resources departments are currently dealing with the impact of the federal government shutdown, the longest in history. During today's webinar, we'll discuss changes to the labor and employment law landscape that have already transpired, like the shutdown, which I just mentioned, and we'll also make some predictions about additional possible effects of the midterms on employers and employees, such as potential new legislation that might be passed. First, we want to start by giving a little bit of background on the midterm elections. The general election, as you might recall, took place on November 6, 2018. At the federal level, the big developments were the Democratic Party gained control of the House of Representatives by picking up 40 seats. The Republican Party strengthened its control on the Senate. Specifically in the Senate, the Democratic Party lost 2 seats. Prior to the midterms, there were 47 Democrats, 2 independents, and 50 Republicans. But now there are 45 Democrats, 2 independents, and 53 Republicans. And of course, the presidency is still held by President Trump, a Republican. Generally, this kind of result where you have a divided Congress, for instance, means that any legislation really has to have strong bipartisan support to have a chance of passing and being signed into law. But as we're learning with the shutdown, even a lack of legislation can have a big impact.
So some of the potential legislation that's expected to have some bipartisan support in Congress that has relevance to labor and employment. There's a good amount of bipartisan support for an increase in the minimum wage. There is bipartisan support for a paid sick leave law, and it's a little bit shakier, but there does seem to be some bipartisan support for more pro-union legislation, including legislation targeted at making it easier to form unions, speeding up the card check procedures, and the effect of speeding up that procedure is that it undercuts companies' abilities to delay the process, and that those kind of delays are usually used to discourage workers from joining the union. So any legislation that speeds up that process is seen as very pro-union and pro-worker friendly. And those seem to be more like middle of the road legislation that could get bipartisan traction.
So next, we wanted to talk about changes in leadership that might impact labor and employment issues. And those are twofold. First is potential changes in the heads of federal government agencies. And then secondly, now that the Democratic Party has majority in the House of Representatives, they now get to select the chairs of the various committees And those are powerful positions. And now those committee chairmanships are all Democrats. So the results of the midterms can impact leadership at government agencies who regulate in the labor and employment arena. Those are the ones that we're concerned about today. This is because agency heads are typically appointed by the president and confirmed by the Senate. So now that there's a stronger Republican presence in the Senate, that's going to have an impact on whether an agency head is confirmed or not. It makes it more likely that probably anyone that President Trump nominates will get through the confirmation process in the Senate. For example, one agency that we're concerned with is the National Labor Relations Board. That board is governed by a 5-person board and a general counsel, all of whom were appointed by the president with the consent of the Senate. By way of background, the NLRB is responsible for enforcing U.S. labor law in relation to collective bargaining and unfair labor practices under the National Labor Relations Act, which is the law that the NLRB enforces. The board supervises elections for labor union representation. They can investigate and remedy unfair labor practices. And unfair labor practices may involve union-related situation or instances of what's called protected concerted activity. And I just want to underscore that all employers need to understand their legal obligations under the National Labor Relations Act. That law does not apply only to unionized employers or employers where a union campaign is happening. We're actually seeing more charges being filed by non-union employees against their non-union employers, specifically alleging retaliation for engaging in protected concerted activity, which means, in sort of plain language, opposing an unlawful workplace policy, even when no organizing in the union sense is on the radar whatsoever. So it's just where a group of employees gets together and protests something that they don't like about the workplace. Currently, the NLRB is comprised of 3 Republicans and 2 Democrats, but that's something, of course, that could change. I want to talk about the Department of Labor also for a second. That's another agency that concerns human resources practitioners. The Secretary of Labor, who heads the U.S. Department of Labor, is appointed by the President with the advice and consent of the Senate. That agency is responsible for occupational safety, wage and hour standards, unemployment insurance benefits, reemployment services, some economic statistics as well. Secretary Acosta is expected to remain in charge of the Department of Labor. He has a pretty conservative agenda. Turning now to changes in the leadership of the various House committees. That change in power impacts the legislation that these government agencies that we're discussing, the DOL, the NLRB, are in charge of enforcing. Also, the House can provide oversight to those agencies that slows down their agendas. They can, hold hearings, subpoena information. So that's sort of a softer impact that the change in power can have on the agendas of these particular agencies. One big change in leadership in the House pertains to the Committee on Education and the Workforce. That committee oversees all matters dealing with workforce-related issues, which includes labor relations and employment-related health and retirement security matters that deal with ERISA. Bobby Scott, who's a Democrat from Virginia, was elected as the new chair of the committee. He's considered to be very progressive, and he's expected to make many changes. So he has said that he wants to, quote, free students from the burdens of crippling debt, support workers' access to fair wages, safe workplaces, and a secure retirement, and expand affordable, accessible health care coverage to all Americans.
So one of the potential pieces of legislation that's going to be potentially coming out of that Committee on Education and the Workforce is potential legislation to overturn the Janus decision, which was made by the Supreme Court last year. And it is relevant to government entities who were deducting union fees from payroll for all employees, not just union members. And the Supreme Court ruled that that practice was illegal. The broader impact of that is essentially that unions are collecting less fees, and historically, unions are very big, significant contributors to political campaigns. There's been some pushback on this decision already at the state level. For example, in New Jersey, they already passed a law at the state level to encourage and protect union membership. One of the interesting provisions of that law was that it's mandatory that the union gets to make a presentation at all new hire orientation to encourage new hires to join the union. So there's rumblings of a similar legislation in Pennsylvania at the state level, but also it looks like on a federal level that Bobby Scott's committee is looking into whether trying to make a decision that would push back on that Janus ruling.
Focusing on some additional potential legislation that we might see in 2019 and into 2020. As I stated earlier, sort of the expected impact, just generically, of a divided Congress is essentially gridlock, except where there's bipartisan support. Due to the government shutdown, as of right now, the focus is on legislation to end the shutdown. But after that is over, as Danielle touched on earlier, paid sick leave seems to be something that a lot of people are getting behind. I'm sure all of you are very familiar with the general trend of paid sick leave legislation. We've seen it somewhat recently in Philadelphia. We've seen it even more recently in the state of New Jersey. Spent a lot of time working with employers, helping them change their policies so that they're in compliance with those laws. And that's not always a straightforward process. Paid sick leave law is expected to be passed by the House. That doesn't mean anything unless there's also support in the Senate and at the executive level. President Trump and the Republicans have expressed generalized support for paid sick leave. But what's unknown at this point is what details would be included in a House paid sick leave bill. Obviously, how many paid days off people get, how big an employer has to be for the law to apply to them. Is it full pay, or is it some sort of percentage of what the employee typically earns? It's possible there could be a lot of disagreement over those details and others that I haven't touched on that would prevent any type of paid sick leave law being passed. However, it is anticipated that the House will resurface the Healthy Families Act, which would require an employer with 15 or more workers, so relatively small employers, to provide up to 7 job-protected paid sick days each year. And you can see on this next slide, what we were talking about earlier is that even though the federal government hasn't really moved on this issue yet, municipalities and states are doing it independently.
So the significance of paid leave is really due to the changes in family structures that we've seen in the past, at least the past decade. This infographic is using statistics from the last census. And as you can see, it's something like half of two-parent families have both parents in the workforce. Something like 30% of families with a child under 18 are single-parent households. So the percentage of families with a stay-at-home parent is the minority, and it's definitely shrinking. So paid sick leave has a lot of broad ramifications.
Turning now to another sort of hot topic in general, mandatory arbitration agreements. So mandatory arbitration agreements have developed a very large presence in the American workforce. Many employees are subject to them. And there's also been some recent big decisions handed down about the enforceability of those agreements. And sort of as a reaction to all of that, it's possible that we might see legislation on this topic. So just by way of background, mandatory arbitration agreements force employees to settle their disputes in a private arbitration forum rather than in a public lawsuit that's filed in the courts. And typically, these forced arbitration clauses are viewed as employer friendly, and there's several reasons for that. I think first and foremost, there's no juries involved. The arbitrator is the one who's making the decision. Sometimes it's a panel, sometimes it's a single arbitrator, but there's no true jury. It's also very difficult to appeal from an arbitration decision, and it's usually thought of a cheaper sort of process to go through than going through the traditional court system. I don't think that's always the case, but that's sort of how it's generally thought of. In November, the House introduced the Restoring Justice for Workers Act, and that bill prevents the use of forced arbitration clauses in employment contracts. So we'll see if that gets any traction. So as I mentioned a bit ago, I think that part of this is a reaction to not just the fact that these agreements have become more and more commonplace, but also because there was a significant decision in May of 2018 by the Supreme Court of the United States. It's the Epic Systems decision. It was a 5-4 ruling. In that case, the court held that employment arbitration agreements with class action waivers requiring individual arbitration are enforceable under the Federal Arbitration Act. And the court ruled that this is the law despite the fact that the National Labor Relations Act protects employees' rights to engage in concerted activities. In plain language, if an employee signs an arbitration clause, they can give up their right to band together with other coworkers to sue in court over workplace issues. Instead, they would be forced to bring those actions individually in an arbitration forum. And any new vacancies on the Supreme Court over the next 2 years may very well add another justice who would add to the body of case law enforcing mandatory arbitration clauses further. There's another infographic that talks about mandatory arbitration clauses in U.S. workplaces, and you can see by those percentages that they really are quite common, and they're even more common among larger employers.
So another area that's sort of in flux right now is this concept. It's called the Persuader Rule, and it came out of the Department of Labor, and it refers to the employer's use of union avoidance consultants, and it required that employers disclose when they were talking to those kind of consultants and what kind of advice that they were getting. And a lot of the pushback on this rule was that union avoidance consultants could often include attorneys and legal counsel that the companies were getting. And the rule required that employers had to publicly disclose those attorney-client relationships and the substance of the advice that they were getting, which made this rule very controversial. So when President Trump took office and his secretary Acosta took over the Department of Labor, they rescinded this rule. And they pointed to that as the primary reason, the issues with attorney-client privilege. So with the change in the House and the change to more Democratic majority in the House, it's expected that there's going to be some legislation introduced targeting this rule, seeking to reinstate it. But it looks like that reinstatement might be more focused on sort of carving out attorneys as a separate category and maybe just requiring employers to disclose just purely consultants for union avoidance purposes, to avoid this issue of sort of muddying the waters with advice from attorneys versus outside consultants.
Moving on to the topic of raising the minimum wage. The Raise the Wage Act was actually introduced by Democratic lawmakers on Wednesday. This new legislation would bring the federal minimum wage to $15 an hour by 2024. I might have this wrong, but I think Bernie Sanders sort of made this concept popular in recent years. The law would further give the Secretary of Labor the power to raise the wage floor without approval from Congress. More than 100 Democrats have signed on as co-sponsors of the House Committee on Education and Labor Chairman Bobby Scott's Raise the Wage Act. Practically, it's expected that if this bill were signed into law, that it would give about 40 million Americans a bump in pay. Once it's fully phased in over the 7-year period, the average affected worker would see about $3,500 extra in annual pay. So it's would have a really significant impact on employees and employers, of course. States have been acting on their own with respect to raising the minimum wage for years, obviously. 30 states have a higher minimum wage than is required by federal law. And in fact, wage hikes took effect in 20 different states this year. For example, in the state of New Jersey, the minimum wage went up a quarter an hour. From last year, it's now at $8.85 an hour. You can see in another infographic there, we have quite a few of those today, showing the states where the minimum wage is above the federal level since 2009.
So that minimum wage increase is one of the things that Governor Wolf included in his platform when he was running for re-election, which he won, by the way. He is looking to increase the minimum wage in Pennsylvania to $12 an hour. He already signed an executive order putting that into place for Pennsylvania government employees. And one of his goals for the next year is to work with the General Assembly to get that passed statewide. Governor Wolf also has vowed to veto any legislation that attacks the workers' right to unionize. During his last term, he vetoed legislation putting a work search requirement on Medicaid recipients, and he also pushed for an increase in the number of people who qualify for unemployment insurance. So in his inauguration speech last week, Governor Wolf really stressed bipartisanship, and he expressed optimism at working with Republican leaders in the Pennsylvania Assembly. And a number of Republicans in the Pennsylvania Assembly, especially in leadership, have done the same. And so it looks like there may be a spirit of cooperation, at least for the time being. There's a pre-existing expectation that the party differences are going to impede progress, which they definitely did during Governor Wolf's last term. But you never know. So it remains to be seen whether they're going to be able to make anything of the renewed spirit of optimism that is going around.
Now we'd like to briefly discuss anticipated changes at the National Labor Relations Board. Again, this board impacts union and non-union workplaces. And probably the biggest topic is the liability of, quote, joint employers. So first, why do we care about who counts as a joint employer under the National Labor Relations Act? There's a few reasons. Because if your workplace is deemed to be a joint employer, you can have really significant legal obligations. It can impact wage and hour obligations. You can be required to bargain with the union representing jointly employed workers. Franchisors, for example, McDonald's in particular, have been concerned that the Obama-era definition means that they will be deemed joint employers with their franchisees, that would just be huge and expose them to so much more litigation and just obligations. So under Obama, the legal test for determining whether or not you were a joint employer was whether or not you exercise, quote, indirect control over the terms and conditions of another employer's employees, or you have, quote, reserved the authority to do so. This definition is really broad, really sweeps in a lot of entities, and as such, it's considered more employee and union friendly. Gives you more potential parties to sue, more potential entities that you can point to as sort of being responsible for making sure that your workplace conditions are legally sufficient. This definition was abandoned during the Trump administration. Under the Trump administration, the legal test is whether or not you exercise, quote, direct or immediate control over another employer's employees. So there has to be a much closer relationship between you and the other employer's employees. This is considered more employer friendly. This definition means that many fewer entities will qualify as joint employers under the law.
So, as Catherine said, the definition is really, that was used under the Obama administration, is very, it's pretty vague, and the DC Circuit just recently came out with a definition suggesting that definition is actually so vague as to be unworkable. The NLRB is currently going through its rulemaking process, so it's unclear where they're heading with this. But it, like Catherine said, it can have really broad ramifications, particularly for like wage and hour issues, like overtime and minimum wage and all of that. So there's a lot of liability at stake. So this is definitely an area of the law to pay attention to if it's relevant for your company's structure.
Another change that we might be seeing at the NLRB, I think, less significant than the joint employer issue, but still significant enough for us to talk to you about today, has to do with a case called Purple Communications. In Purple Communications, the Obama-era board expanded employees' rights to use company email systems to engage in solicitations for union-related communications. So that means that an employee can use their company email system to, send emails to hundreds, thousands of employees, soliciting them to participate in a union and trying to organize. A lot of employers don't like the idea of their business email systems being used for organizing purposes. But, on the other hand, if you're an employee who wants to organize, obviously email is a very, very powerful tool for you to communicate with your coworkers. The Purple Communications decision was pretty narrowly tailored. It was really just email only. It didn't authorize this type of solicitations through text messages or other apps or devices that employees might use regularly in the course of their work that are, obviously owned by the employer. The current board has stated that it is reviewing the Purple Communications decision and whether or not to overturn it. So we will see what they do.
So the general takeaway on the overall issues with the NLRB and interpretations of the NLRA are that the rules are shifting, the regulations are constantly being drafted and revised. There are a number of cases working their way through the courts right now. So this is an area of the law to pay attention to, particularly if you have a unionized workforce, but it's certainly relevant even if your workforce is not unionized. Okay, turning to the government shutdown. We're now on, I believe, day 33 of the federal government shutdown. It's the longest shutdown in the history of the country. It began on December 22nd, and essentially the government is not fully funded. The big pieces of that are certain federal employees aren't being paid, and of those not being paid, some are being forced to work without being paid. And also certain government services are not available. The impasse here, and I don't mean to bore you all because I know it's all over the news all day, but the impasse is over the inclusion of money in the budget to build a barrier wall along the southern border of the U.S. It's estimated that about 800,000 employees are working without pay and 380,000 employees are furloughed. This includes employees of many different federal agencies and entities, TSA staff, I know that's been on the news quite a bit, Border Patrol staff, Coast Guard, Federal Aviation Administration, air traffic controllers, employees who work at NASA, federal corrections officers. So that is a big impact on federal employees, for sure. So, I mean, one of the most, timely things is that I think it was announced last week that the IRS is starting to bring back furloughed workers to work without pay so that they can get started processing people's tax returns. I think it was yesterday the USDA said they're going to start calling back about 10,000 workers without pay to work on the loans for the farmers, and which falls under their office's purview. So piece by piece, workers are starting to be called back without pay. Many of the departments have been funded through 2019. The Department of Defense, Department of Labor, Homeland Security, Commerce and Agriculture. And there was a lawsuit filed a couple weeks ago on behalf of federal employees who are being required to work without pay. The lawsuit focuses on the 13th Amendment and the 5th Amendment, which it says are being violated by requiring people to work without pay. The 13th Amendment abolished slavery, and the 5th Amendment was about due process. And that focuses on the fact that federal employees are not permitted to take outside employment, regardless of the fact that they are not actually working. And that is because of federal ethics laws that don't permit workers to have any type of conflict with their role with the federal government. And unions have also filed similar types of suits, focused on the fact that workers are coming to work every day and not getting paid for it. Another piece of this issue is unemployment compensation. Workers who have been furloughed and are not coming to work every day are eligible to get unemployment, but people who are still working, such as TSA workers who are working without pay, are not eligible for unemployment because they are still technically working under the Department of Labor's legal definition of working. A lot of Democratic governors have sort of tried to take this up with Secretary Acosta to get an exception to that rule so that those people can at least be getting unemployment compensation during this time. I don't think there's been any progress on that, but that type of exception to the unemployment compensation rules did happen the last time there was a shutdown of this size. I think it was in the mid-90s. So there is precedent for that. So we'll see if that actually happens.
Another thing that's been impacted by the shutdown is that the E-Verify system has been suspended. So I expect at least some of you are familiar with the system. E-Verify is the federal government's electronic employment verification system that confirms eligibility for new hires. Not everyone is required to use it, unlike I-9 verifications. Employers enrolled in E-Verify are required to use the system to run checks on new workers within 3 days of hiring them, or at least that was the rule until the shutdown. The E-Verify system is not currently operational, so it's impossible for employers to comply with the law and that 3-day rule. The result is that the 3-day rule has been suspended. But keep in mind that the shutdown has nothing to do with an employer's responsibilities to complete that I-9 form in a timely fashion. Employers are required to complete Section 1 of I-9 Honor before the first day of employment, and employers have to complete Section 2 of the I-9 no later than the 3rd business day after an employee begins work for pay.
So employers who do have to comply with that E-Verify system should plan to check all new hires retroactively once the shutdown ends. And there is going to be an extended time period to resolve tentative non-confirmations. Days that the government is closed are not going to count towards that time period. It'll just start when the government reopens.
So what's next? The shutdown has cost the U.S. economy, it's been estimated billions of dollars so far. Certainly businesses that serve the DC workforce in particular have been severely impacted. There's a story on the radio this morning about, food carts in front of federal agencies, restaurants that serve lunch and coffee. They just really don't have any business right now. But, the impact of over 1 million people not being paid, of course, is going to be felt in the generalized economy. It's not clear when the shutdown will end, although there are some bills being introduced that would end it, so we'll just have to see what happens. The federal courts, my understanding, will run out of money at the end of this week. And my guess is that that's going to likely slow down litigation involving businesses, including any employment lawsuits that are out there. I think that's just probably a practical result of what's happening. They still will be, functional in some respect, of course. The EEOC, the Equal Employment Opportunity Commission, is no longer funded. And I apologize, there was a slide earlier that suggested that they were funded through 2019, but they're closed. Employers can expect to see a drop in charge-related activity, including investigation. I know just based on my own personal practice, I haven't heard anything from the EEOC since the shutdown began. I know Danielle mentioned to me that she tried to access the EEOC's online filing system, and you just can't log on. It's not operational anymore. Mm-hmm. I think it probably goes without saying that employers should still comply with all labor-related law despite the shutdown. Shutdown's not going to last forever, and any violations of labor and employment laws likely will not be forgotten by employees, and they will raise them with the EEOC once the EEOC is back in business.
Okay.
So thank you all so much for your time this afternoon. We hope you've enjoyed this webinar, and I think we're going to be taking questions now.
Michelle. Okay, we're now going to open it up for questions. If you have questions for our speakers, please type it into the question box at this time.
Okay, Alina, we'll turn it back over to you. Thank you to our speakers for taking the time to share their knowledge with us. Thank you to each of you for joining us for today's webinar. As a reminder, please look out for the follow-up email with the link to the survey, and be sure to complete the survey in order to receive HRCI and SHRM credits, and visit www.phillyshrm.org to register for other upcoming events. We encourage you to check out the Philly SHRM website for updates on all of our upcoming programs. On behalf of Philly SHRM, thanks again and enjoy your afternoon.